Jack Smith and Donald Trump file their joint status report. Welcome to Law and Society. Please subscribe and let's talk about this briefly. At the get go, I'll give you a brief idea. The government, Jack Smith and uh, the DOJ, want to follow the Supreme Court's mandate in Trump v. United States and determine the question of immunity before moving forward with any of the other considerations and motions. And the DOJ wants any other considerations and motions to happen parallel to the evidentiary hearing that needs to happen regarding Donald Trump's immunity. So that is in adherence to the Supreme Court. And Jack Smith, at the very get go, clarifies that it is up to Judge Chutkan's court how she sets the schedule. But, not but, and in order to help Judge Chutkan, the government provides a sort of outline, not timed outline, but sort of an outline of how it will present its evidentiary hearing and how it plans to address the other motions and asks the court to set it parallel with the immunity hearing. Donald Trump, on the other hand, has proposed, has not referred to the fact that the district court has broad discretion in how it manages its procedures. It has proposed a schedule for the court to consider and adopt. And part of that schedule is for Donald Trump to be able to raise other motions other than and go about assessing what concerning the special counsel's improper appointment, and they want to address that first. So then the first actual thing that they want is disclosure of Brady, of any exculpatory evidence that the prosecution may have regarding Donald Trump's immunity. And then they skip over and then they go to going over other motions and says that if you don't go over these motions, it goes against what the Supreme Court said, where the Supreme Court was very clear that before any procedure happens in the substantive case, the court must make a determination of the immunity, of whether there's an immunity on the various acts that are alleged. And to that effect, Jack Smith's superseding indictment, they also want time in order to go through that and be able to answer that. But in the interim, they would like Judge Chutkan to be able to resolve other matters before going into the evidentiary hearing that SCOTUS has required of a district court when there is a criminal case against a former president. So I believe that Judge Chutkan will set her own schedule. I don't think that Judge Chutkan will take Donald Trump's schedule and adopt it. I believe that Judge Chutkan will conduct these hearings and the motions, parallelly with the immunity hearing. I think that Judge Chutkan will give the defendant some time to reply to the superseding indictment. And I think that at the end of the day, Judge Chutkan will go through the immunity procedure first, because that's what the Supreme Court has remanded the case to do, and remanded the case back to Judge Chutkan to do. So that's just giving you a brief of what the status report is about. Now, what I'm going to do is I'm just going to go through a few highlighted portions that I thought that were interesting. The parties have conferred and set forth their positions below jointly where possible. And the only place that it's possible is for both parties to ask for the court to set a deadline and court to set for filing any of the motions. So it's asked. The only thing that the two parties agree on is that Judge Chutkan needs to set a schedule for what is going to happen. The government's position is that the court has indicated that it intends to conduct its determination related to immunity first and foremost. And that is the government's position as well. The government agrees with this approach, both because the Supreme Court directed such a process on remand and because the Supreme Court has repeatedly stressed the importance of resolving immunity questions at the earliest possible stage in litigation. To the extent that the court considers the defendant's other planned motions, the government proposes that briefing schedule for those run parallel with the schedule for immunity briefing. And in order to support the government's position, here are a few suggestions for the court. For immunity determination, the court's decisions on how to manage its docket are firmly within its discretion. So here we see that the DOJ is giving the court deference and understanding that it is ultimately up to the court and not setting a schedule in front of the court saying you need to follow this. That's what Trump's lawyers are doing. To allow the court to undertake the fact-bound analysis that the Supreme Court prescribed on remand, the government proposes that it file an opening brief in which it will explain why the immunity set forth in Trump does not apply to the categories of allegations in the superseding indictment or additional unpled categories of evidence that the government intends to introduce at trial and will proffer in its brief. The government's proposed brief would provide the defendant and the court with detailed information regarding the content, form, and context of the defendant's conduct, distinguish his private electioneering activity from official action, and rebut the presumption of immunity as to any conduct that the court may deem official. The defendant also intends to file a motion to dismiss the superseding indictment on the basis that the grand jury that returned it was exposed to immunized conduct. Because considerations of that motion would require the court in the first instance to make the very determinations described above, the government believes that the court should consider the defendant's grand jury claim only after conducting the fact and context specific analysis of whether the superseding indictment contains immunized conduct. So the DOJ here is asking the court to follow the Supreme Court's precedent in Trump, the United States, saying that we need to deal with the immunity question first, because the Supreme Court admonished both the appellate court and the trial court for not even considering going over the immunity question and seeing whether each of the conduct has immunity. And that's why it set forth those three categories in Trump v. United States, said there's a presumption of immunity that the government can rebut, and then also a category where it's completely official acts that are out of question, and then there are private acts. So in the superseding indictment, there has to be a determination, because it is a new indictment from a new grand jury, mind you, who was not exposed to the first indictment. So they are looking at this freshly, and they have returned a recommendation of indictment. So the government, and so the government believes that uh, the court should consider the defendant's grand jury claim only after conducting these fact finding, the fact and context specific analysis of whether this new indictment has immunized conduct. And Donald Trump will later on, we'll read, doesn't want to go through fact and fact and context specific analysis. So there's a small difference there between but it's a very big difference. You know, Donald Trump is saying that we want to defeat this as a matter of law. We will talk about the context and we will talk about the context, form, and content, but not going far as to say that we will also do a fact. So, I mean, I don't understand how the defense can say that the Supreme Court didn't mean fact when it said content. Obviously, the content and the material of the indictment is necessary to determine whether the conduct alleged is immunized or not. So that information has to be presented. The government is prepared to file its opening immunity brief promptly at any time the court deems appropriate. In regard to other motions, the defendant plans to file additional motions to dismiss. The court has indicated that it will conduct its immunity determination before resolving those issues. The government notes that it may promote judicial economy for the court to schedule briefing of all Rule 12 motions concurrent with the immunity litigation. If the court sets a deadline for the defendant's other motions, the government requests that the court set the same date for the defendant's opening brief as for the government's immunity opening brief, followed by parallel opposition and reply deadlines. So here we have like giving the court an idea that we would like for it to run concurrent. We would like for it to have a parallel proceedings happening with each of with you know the defendant's opening brief and then the government's opening immunity brief, you know, in the other motions. So the motions can run concurrently. The government does not see a reason to delay immunity determinations and other pretrial litigation to separately address the defendant's pending or proposed discovery motions. So, with that said, it leaves it up to Judge Chutkan of how she adopts. And Donald Trump's position at the very get-go, it gives a schedule, proposed schedule. You know, September 30th. So next month, end of next month, you give us all the exculpatory evidence that you have, if you have any, regarding presidential immunity. Then a month later, in October, they want to consider a motion concerning the special counsel's improper appointment. Mind you, we will come back to this in the reading. This talks about the concurring opinion of Justice Thomas, casting doubt on whether the special counsel has the authority to go over to actually bring these cases. And we know that Judge Cannon dismissed the Mar-a-Lago case on that ground, and by holding only Justice Thomas's concurring opinion, which is not the rule of law, by the way, it is dictum. So as it stands now, the only court that has adopted that procedure is Judge Cannon's court. And the defendant, Donald Trump, here very proudly makes that up, as if it is in any way binding to Judge Chutkan, which it is not, because it's a district court from the Southern District of Florida, whereas Judge Chutkan is in the District of Columbia. Then December 3rd, so then November, there are some deadlines that they want. And then on December 13th, defense motion to dismiss based on presidential immunity. So they don't want to start off with the presidential immunity thing first. They have pushed that back to December 13th. And then the week of January 27, 2025, non-evidentiary hearing regarding motions to dismiss and compel. So they're just stretching this out, like it's going to take us some time. And they start out with the rationale for it is that the special counsel has entered a superseding indictment that includes substantial changes to its prior allegations. First of all, if you read both the indictments, and I have this, the changes is that the DOJ has just removed any conversation with officials and like the DOJ officials and Jeffrey Clark's case and that involvement out of the indictment. It has then presented the case in the context of Donald Trump being an office seeker and a campaigner as opposed to his official functions, and has shown why each of the functions, each of the acts committed were acts that Donald Trump did not have constitutional authority over, which is namely electioneering his own election. So that is private conduct. And, Jack Smith makes that clear in the superseding indictment, but it doesn't change it substantially. It actually keeps the bulk of it. President Trump correspondingly requires time to review the new charging instrument as he determines what steps and procedures to undertake regarding, among other motions, his presidential immunity defense. President Trump holds the right to challenge the new indictment and the underlying grand jury process as a matter of law. Yes, of course you do. First, you address the immunity, but that's not what Donald Trump wants. Here, Trump is considering several challenges to the superseding indictment, each of which should be resolved in his favor as a matter of law and would obviate the need for further proceedings. So he's asking for more motions that he will file. Then he goes, as a threshold matter, President Trump will move to dismiss the special counsel's improper appointment and use of non-appropriated funds issue that a Supreme Court justice describes as serious questions that must be answered before this prosecution can proceed, and which a district court has found dispositive, meaning canon. So they're trying to bring it into law that there is, and by the way, this particular specific issue is what Jack Smith has appealed to the 11th Circuit in the Mar-a-Lago case. So that case is not over. It's in appeal. It's pending appeal. Namely, in Trump, the precedent, the Supreme Court held that President Trump is at least presumptively immune from prosecution for all alleged efforts to pressure the vice president to take particular acts in connection with his role at the certification proceeding. Well, then the idea of presumptively immune is that the government gets to rebut that presumption. And that will be presented as a matter of law because the vice president, and I've talked about this before, the vice president acting when talking about certification proceedings is acting in his capacity as president of the Senate and therefore a part of of Congress, Article 1 branch of government. And the speech or debate clause or any form of presidential immunity does not attach to the officer of Congress as president of the Senate. One. Number two, no speech or debate clause protections protect Vice President Pence from answering questions about Donald Trump, because the whole point of the speech or debate clause is to protect Congress from an overreaching executive. So you see here, Donald Trump is saying that we are immune, presumptively immune for whatever is being said about Vice President Pence, but that the government gets to rebut that presumption. That's the whole meaning of presumption. We presume it, like presumption of innocence until proven guilty. It's the same thing. It's presumptively immune until proven otherwise. Then he goes on. If the court determines, as it should, that special counsel cannot rebut the presumption as these facts are immune, binding law requires that the entire indictment be dismissed because the grand jury considered immunized evidence. First of all, that will be contested, and the grand jury was not the same grand jury that considered the previous case. Therefore, they were not. They did not consider immunized evidence. They considered evidence that was presented by the DOJ for the superseding indictment. Take a quick drink of water. This is, almost over. Sorry. I wanted to go through this because I want to show you how Donald Trump does not give deference even to the Supreme Court thing. It's like, yeah, Supreme Court wants to do the immunity thing, but what we're going to do here is we're going to go through these other motions and then we're going to deal with the immunity thing. I mean, it's like reckless disregard for the rule of law and the institutions that we have. Excuse me. Then it goes on to saying the special counsel's inability to rebut the presumption as to Pence is dispositive in this case. It's dispositive once you present the presumption, once you present the evidence, once you present the context and the content of the materials, that has to be determined by the trial court. So it reads into part of this is a part of Trump v. United States. We therefore remand to the district court to assess in the first instance the appropriate input from the parties whether a prosecution involving Trump's alleged attempts to influence Vice President's oversight of the certification proceeding in his capacity as President of the Senate would pose a danger of intrusion on the authority and functions of the executive branch. It has nothing to do with the executive branch. There's that particular certification proceeding in his capacity of President of the Senate has nothing to do with the executive branch. It has something to do with the electioneering that Donald Trump was doing. Election matters are vested to Congress and to the states by the Constitution. And Donald Trump just seems to not understand that, and neither do his attorneys. Then Donald Trump brings up the issue of Supreme Court's decision in Fisher about the obstruction ruling, and it claims that it will, that will move to dismiss that charge on the basis of Fisher. Again, Fisher said it was fact specific in each of the cases. So if Jack Smith here believes that he has enough proof and the grand jury believes that there is enough proof and that's put in the indictment, that there is enough proof to show that Fisher does not apply here, or even under Fisher, this charge of obstruction applies to Donald Trump, that is something that will happen when the trial starts, when there's a fact finder and a jury. Accordingly, it is necessary to address and resolve this issue as a matter of law. Well, of course it'll happen, but it'll have to happen after the immunity, because that's what the Supreme Court said. Then it goes on to say, our proposed calendar accounts for this, yet still moves the case forward expeditiously by scheduling an appointments and appropriation motion in October before, if necessary, and the case is not dismissed as it should be, turning to questions of presumed immunity and Fisher in December. That goes against Trump versus the United States, which said that you hold the immunity proceeding first before doing anything about appropriations and appointments, about improper appointment of counsel and the obstruction motion because of Fisher. Those all have to happen after the immunity under Trump v. United States. But here, Donald Trump is saying, oh no, we can just do that later on. Such a schedule not only promotes judicial economy, mind you, he has extended it into January, into next year, and then he's saying it promotes judicial economy, but also and vitally preserves the separation of powers by minimizing unnecessary litigation regarding President Trump's official acts. Well, the superseding indictment specifically talks about private acts, talks about him being a campaigner, talks about the president not having authority in election matters and campaigning matters. Well, he has, as a campaigner, can, but he cannot influence or have any constitutional authority to go about manipulating the election process. That's up to Congress and the states, and that's why we see that in the superseding indictment at every turn how uh, the DOJ points to private conduct. And so it follows, therefore, that the court should take every reasonable step possible to resolve the case on legal grounds before permitting an invasive public inquiry regarding Trump's official conduct while in office. Talking about this invasive inquiry is the evidentiary inquiry that the Supreme Court ordered because it said that there's presumptive immunity. So Donald Trump wants to have the cake and eat it too. You know, we believe and expect to demonstrate that this case must end as a matter of law. Well, so let's do it with the immunity first, like SCOTUS said. As a result, with respect to unclassified and classified discovery, there are serious threshold questions to be addressed about compliance with Brady, which is exculpatory evidence that prosecution may have against the defendant. They have to turn that over. I don't know what exculpatory evidence prosecution has against Donald Trump, but they want to talk about it. Therefore, we have proposed a deadline of September 30th for that, of course, because that is more important than what the Supreme Court said. To ensure President Trump has the full universe of potentially relevant documents, the court must permit him the opportunity to serve new immunity-focused discovery requests and seek relief from the court if the special counsel denies access to such documents. Nothing of that sort has happened. The special counsel has not denied any discovery. In fact, they have facilitated discovery and moved the cases forward in all the cases, meaning the two cases, the Mar-a-Lago case and the DC case. The parties will, of course, attempt to resolve any such disputes without motion practice. However, the reality remains that immunity discovery must be requested, negotiated, potentially litigated, and exchanged before any evidence-based submissions are right. This will necessarily take time, of course, so we should do it first. But that's not what Donald wants. The need to resolve such issues is simply incompatible with the near immediate evidentiary submissions the special counsel proposes. Well, the evidentiary submissions and the content and context of the case as it refers to immunity must be presented to the district court before any other issue under Trump v. United States. Moreover, Trump has had no opportunity to cross-examine the special counsel's witnesses or call witnesses of his own, leaving the evidentiary record incomplete and incapable of supporting fact-based submissions. Mind you, DOJ has not provided a timeline for when it's going to do so. It's asking the court for it. So it is up to the court to decide how the immunity and the fact-based submissions are going to be filed. And that's what they're asking for. Whereas here, the defendant Donald Trump is telling the court that we want it to be done this way and extended this way and not hold the immunity proceeding first. Proceedings of an evidentiary submission in this posture would violate fundamental Sixth Amendment principles, including the right to present defense witnesses and to cross examine government witnesses. Well, then Judge Chutkan would have to determine how to go about the Supreme Court's decision to check the context and content of the material that is to be looked at to see whether it is presumptively immune or not. Because there is nothing in the superseding indictment, according to DOJ, that is official. There's no official conduct in the superseding indictment. There are a few instances where there's presumption of immunity, and as DOJ said, they plan on rebutting that presumption once they get the briefing schedule. The special counsel has drafted and filed its superseding indictment as it saw fit. It is now President Trump's right to challenge that indictment through appropriate motions and argument. The special counsel has no right to preemptively challenge submissions President Trump may make. I don't see the special counsel preemptively challenging any submissions. It is just saying that you run it concurrently with the immunity hearing. The DOJ has not said anything about it having, doing it before. They're saying do it parallel, doing it at the same time. And even that is not acceptable to Donald Trump. So that is the status report, and that's where they stand. They don't agree on anything except that Judge Chutkan needs to set the schedule. And I don't believe that Judge Chutkan will take the suggestion of Donald Trump's attorneys and go with the scheduled review of the Brady motion before they do then they would do the special counsel improperly appointed motion, and then they would do the Fisher motion, and then they would do the immunity motion. That's not what the Supreme Court said. The Supreme Court said you do the immunity first. And in a case where the former president is defendant under Trump v. United States, you do the immunity inquiry in the case first. And the superseding indictment has made that easier for both defendant and the court because it has taken out any part of the indictment that ever touched any official acts. And we'll have to see how Judge Chutkan rules on this matter. But I believe that Judge Chutkan will adopt a faster schedule. And I believe that Judge Chutkan will take into consideration running these proceedings parallelly and concurrently as the DOJ requests, because there is something to be said about the coming out of factual evidence and not being able to cross-examine. But I mean, Judge Chutkan has a discretion of letting there be cross-examination in an evidentiary hearing if fact-based witnesses are brought and if there are factual determinations that Judge Chutkan believes needs to be made under Trump v. United States. So, Donald Trump is flouting Supreme Court's decision that was in his favor and saying that we're not going to do the immunity thing first. I don't think that's going to fly. So with that said, this has gone on for 30 minutes or so. If you like what you've heard, please please subscribe, and please share. That's the way that word gets out about my channel. And I could really use some of your help in getting the word out. So with that said, thank you, and I will talk to you soon.